So here's what complicates everything. And you're like, oh, wait, this is turning into a law school class, and Brendan doesn't even have a JD to be able to teach this. But here's why this is absolutely fascinating from a procedural standpoint that actually affects why everyone should care. Essentially, we have so far a couple of defendants, and we expect Donald Trump to join them, going to federal court here in the Northern District of Georgia and asking a federal judge to remove the case. Mark Meadows is one of them, the former White House chief of staff, saying, let's remove this to federal court. Now, I don't want to bore you with all the details because you're saying, wait, this is a state case, this is a Fulton County case, why would it go to federal court? Their argument is that they were federal officers, that Mark Meadows was serving as the White House chief of staff at the time, and everything he did was at the direction of the then president of the United States, so this would come into this sort of under the color of his federal officer position. So he didn't do these things as a private citizen, he did them as a federal official, and therefore he's entitled under federal statute to remove these state charges to federal court. Why it matters is because, and by the way, a lot of people are getting this wrong. This doesn't mean that now federal pardons are in play. There's still state charges, and if there are convictions in federal court, they would be under Georgia law. And the Constitution does not allow, it only calls for pardons for any offense that is, brought by the United States of America, not by state charges. So this doesn't invoke any kind of opportunity for a pardon for anybody. What it does do, though, is it puts it in front of a federal judge under federal rules and the federal court rules, even though it's a state charge. Fani Willis and her assistant DAs would actually prosecute the case in federal court, but under state law. So again, it's really complicated, but here's the big issue for Donald Trump in particular and his co-defendants as well, is that if this gets removed to federal court, and it's possible all the cases get moved to federal court, because if one goes, if they say, Mark Meadows, yeah, you were a federal officer, the co-defendants can say, look, this is a RICO conspiracy case, it's all tied together, we need to be tried in federal court too, even if we weren't federal officers. David Schaefer's filed, for example, he was the GOP chair in Georgia, and he's filed because he said, I was an elector, and as an elector for Donald Trump, I was essentially a part-time quasi-federal officer. Whether or not that's a stretch of an argument, all the defendants could end up in federal court if the court agrees with this. And here's the big issue, is that it would open up the jury pool to not just Fulton County, which is very diverse, politically and socioeconomically, racially. It would open it up to a much broader swath of the Northern District. So you'd bring in areas like Cherokee County, which went overwhelmingly for Donald Trump, where Fulton County went for Joe Biden. So you'd have a much broader and more, frankly, more conservative jury pool, and that's the jury pool for these state charges in federal court if that happens. So you're saying, okay, what's next, Brendan? This is all really academic and interesting, but what's really going to happen next? What's going to happen next is Monday. There is going to be a hearing in federal court in the Northern District of Georgia in front of a federal judge where Mark Meadows and his attorneys are going to be able to argue for this removal. No matter who prevails, no matter what the judge decides, and by the way, it shouldn't matter, but it's an Obama-appointed judge versus a Kemp-appointed judge in state court, which complicates matters a little bit, because do you want to stay, if you're Donald Trump and his co-defendants, do you want to stay with the Kemp-appointed, more conservative, though respected judge in state court in Fulton County, or do you want to go with the Obama-appointed judge in federal court? Again, it shouldn't matter, but it's part of the calculus. No matter who prevails in that Monday hearing when the judge finally rules on removal, they're going to appeal. And the appeal, because it's a federal motion, is going to be to the 11th Circuit U.S. Court of Appeals, which is here in Atlanta. It's basically one stop before the U.S. Supreme Court. And again, not to turn this into a law school class, but under state charges when you appeal to the Georgia Appeals Court. So if you have any issue that arises in Fulton County and you don't like the outcome, you get to go to the Appeals Court of Georgia, and then the next appeal is to the Georgia Supreme Court. In federal court here, we're in the 11th Circuit, which includes it's Georgia, Alabama, and Florida. You appeal to the 11th Circuit U.S. Court of Appeals. That's a very conservative appeals court here in Atlanta. And so no matter who prevails on this withdrawal motion, it's going to go before, it's definitely going to be appealed to the 11th Circuit U.S. Court of Appeals. It's just, it's automatic that whoever loses is going to go and appeal that. And then no matter what the 11th Circuit rules, you have the option to appeal to the Supreme Court of the United States. Now, the Supreme Court of the United States doesn't have to hear the case. They grant something called cert. It's short for a longer Latin name, certiorari, basically means granting the ability to hear the case. And the Supreme Court picks and chooses which cases it hears. But a case involving a former president of the United States is likely to be granted cert, at least on an emergency basis. They may hear this removal case. So this little case, and I don't mean to call it that, but compared to the U.S. Supreme Court, this little case in Fulton County, Georgia, might end up in front of the U.S. Supreme Court sooner than later in terms of if there is a removal to federal court and Fani Willis wants to appeal it all the way up there, or if there's no removal and Donald Trump wants to take it to a Supreme Court where he's appointed several justices, does he want to go and make that argument? So we have some really interesting procedural things that are going to happen in the next several days, really. I mean, this is going to happen really quickly. The next thing that's going to happen is the week of September 4th. Starting on September 5th is when Fani Willis, that's a Tuesday, when she wants to hear these arraignments. That would be in front of Judge McAfee unless a removal occurs for one or more defendants. The arraignment is simply a reading of the charges in front of the defendant or defendants, and would be read by Judge McAfee, and then there would be an enter of a plea. The judge would say, how do you plead? Are you not guilty or are you guilty? And we expect a bunch of not guilty pleas, and then that starts the trial process. And the trial process doesn't happen immediately. As we said, it can take weeks and months and sometimes years.